FOIA appeal, opinion from the Mayor's Office of Legal Counsel, FOIA Appeal 217-90R8, that states that an anonymous person is entitled to submit a FOIA request under DC law, and for the purposes of submitting a FOIA request, their identity is generally immaterial. So what are records under DC FOIA? Public records include all books, papers, maps, photographs, cards, tapes, recording, vote data, including ballot definition materials, raw data, and ballot images, or other documentary materials, regardless of physical form or characteristics, prepared, owned, used, in possession of, or retained by a public body. Public records include information stored in an electronic format. And that information is found in DC Official Code sections 2-53910 and 2-50218. Well, what if the records are stored on the personal server and private email account at the agency's director's home? So these are records that are not stored in a District of Government facility. They are not on the District of Columbia server or in the District of Columbia email. Are these records under DC FOIA? Here are your choices. They are still agency records that may be subject to search of the private email. They are not maintained by the government, therefore not public records. They are not government records and lose their character once on the private server and email. So if the records are not maintained on a District of Columbia server or in a District of Columbia email, but they're on a private email and personal server at a director's home or some other off-site location, are they records subject to DC FOIA? And these are the three choices. A is the correct response. They are public records subject to FOIA. There's a court ruling that basically says that if they're stored on a private server or email, that the a search can be undertaken of the director's private email account. But in a particular court ruling, the court found that even though they were on a private server in a private email account, they were not subject to a FOIA search on those particular items. Anybody have any idea why? And this is just a question for you to think about. We're going to look at the what the case said, and there are two different rulings. First, where an agency refused to provide requested records on the basis that the agency had maintained them on a private email account in his name at a site other than the government email site, which the agency had searched, the requester's FOIA compliance action was erroneously dismissed because an agency could not shield its records under FOIA by the expedient of storing them in a private email account controlled by the agency head. If the agency head controlled what would otherwise be an agency record, then it was still an agency record and still must be searched or produced. It was not apparent that the domain where the email account was maintained controlled the emails therein to the exclusion of the user. The agency's claim was inconsistent with the purpose of FOIA, which was to serve the citizen's right to be informed about their government. So initially, the court said these emails are government records, even though they're on a private server and in an email account maintained by the agency head that's off-site from any government facility, that they were in fact government records, and that a search could have been undertaken of that server and those private emails. But in a later ruling, and this is very important to us as we'll see in a couple seconds, the court in that same matter, after an argument by the government, the court stated the government contention was convincing that it need not produce the employee's Office of Science and Technology Policy Woods Hole emails, and those were the emails served on the private server and email address, because there were duplicates of emails that existed on the OSTP servers. The government has established, and the requester failed to convincingly challenge, that the employee complied with agency policy requiring him to forward all work-related emails from his private email account to his OSTP email account. The presumption that he complied with OSTP policy was further strengthened by evidence submitted by the government. The government did not have to produce the emails, the employee's work-related Wood Hole emails as they existed in his Wood Hole account. It did not have to produce those copies of his emails existing in his OSTP account, which it found appropriate to produce under FOIA. And that is important because we are government employees, and sometimes we may find it necessary to use our private email address to conduct public business. There is a mayor's order that speaks to this, and that's Mayor's Order 2012-102, and it's dated July 10th, 2012, and that was about 5 years before the court's ruling in the matter we just looked at. And it lists the purpose of the mayor's order, accounts to transact business and ensure that all emails sent to or received by district government employees in which those employees are transacting business are captured on servers managed by subordinate departments or their agencies, or by the Office of the Chief Technology Officer, and available to Freedom of Information Act requesters as well as to investigative demands. Here's the part that's really interesting and really got my attention. Again, this is 5 years before the decision in the court matter we just looked at. It is the policy of the District of Columbia that district employees are strongly discouraged from using private email accounts to transact public business, and should do so only in rare instances where access to their district provided email account is for practical reasons not available. So if one were to use their private email account to conduct public business, under the first ruling, that email could be subject to search under FOIA to get those records. But number 2 in this mayor's order, I think provides us with a great deal of protection, as well as the court case, if we follow what both say. In instances where private email accounts are used to transact public businesses, whether the email is sent or received, an employee shall ensure that a courtesy copy or blind copy is sent to the employee's district-provided email account. It shall not be a violation of this policy for an employee of the district to receive at a private email address an email regarding public business, so long as the employee ensures that a CC or BCC is sent to the employee's district-provided account. Now, in the case that we just looked at, initially, the court's ruling was, yeah, we can search that private email account to get that information. But when the government produced evidence and a policy that said and showed that the employee had copied to his government email address all the emails that were sought, then that prevented a search of his or her private email address, and the case was pretty much resolved. So if it absolutely has to be done in rare instances, then please be sure and please advise members of your staff and your agency director to be sure to follow the mayor's order by copying or blind copying that email address, whether it's received or sent from that private email address to their District of Columbia email address. And in those instances, based on the court ruling, it should prevent a search of your personal or private email address because the information is stored on a government server. So your private email should be safe as long as you follow the mayor's order and the court's ruling in the case. Oh no, that record shouldn't have gone out. What should I do? In the course of being a FOIA officer, perhaps, and hopefully this won't occur, a document or a record is released that either should not have been released in entirety or should have been released with redactions. What should we do in the event that that happens? The record is already out. If you notice it right away, just when you send the email, I think you may be able to retrieve it. But if you find out a day later or 2 days later, and it's clear that the recipient has possession of that information, what should you do? The choices are do nothing. No one knows but me. Immediately notify the MOC. Immediately notify your general counsel unless you are the agency general counsel. So a record has gotten out that shouldn't have gotten out either at all or in the form that it went out without some appropriate redactions. And you become aware of it. It's too late to pull the email back. Here are your choices. You can do nothing because no one may know about it but you. Immediately notify the Mayor's Office of Legal Counsel or immediately notify your GC unless you are the agency GC. Those are your choices. Think about it for a few minutes and we'll go to the response. I would go to C, and that is to notify your general counsel immediately and to have them take action because of something called the public domain doctrine. And if you want to read about it, it's found in this case, Niagara Mohawk Power Company versus United States Department of Energy. And I think I'm missing part of the site. I'll be sure to get the rest of the site for you. And in this, under this doctrine, if a permanent and complete record has been released in the public domain, this record gets out and the court didn't deal with how it got out, but if it's in the public domain and there's a party who's asserting a claim that the record has already been released, who wants to get a copy of it, and they're able to identify the specific information in the public domain that appears to be duplicate in that information that's being withheld. And here's the scenario. A record has been released and someone in the public has it. Someone else knows about it and they come to the agency saying, I want a copy of record X. Agency says, oh, we can't give you that record because we can only give it to you in a redacted form. The requester says, no, I want it in unredacted form. Mr. Smith has it in unredacted form. If that person is able to identify that a permanent and complete copy of the record in that unredacted form is in the public domain, under DC FOIA law, the agency can't rely on the exemptions that would typically be applicable to withhold the unredacted copy from them. In that instance, the government will have an obligation to take action to get that record out of the public domain. And whether that means going to court and enjoining the party, having it placed under seal, take some sort of action to have it removed from the public domain. Otherwise, the agency can't rely on those exemptions, which are valid, to refrain from allowing another party from getting that same record. And here's the complete citation. So to do nothing would be a horrible thing to do. Notifying the MOC would not necessarily solve the problem. Notifying your GC, who would then be in a position to take some legal action to get the record back, is the best course of action. So a question would be, well, if the record's already in the public domain, why is someone willing to go to court to get a copy of a record that is already publicly available? And the court dealt with that in its decision. It says Niagara's position is a little odd. If the information is publicly available, one wonders why it is burning up counsel fees to obtain it under FOIA. But the logic of FOIA compels the result. If identical information is truly public, then enforcement of an exemption cannot fulfill its purposes. So the court says basically FOIA would require it to be processed without those exemptions, since the identical information is already out in the public domain. We work with private contractors. Do any records include their records? So, of course, a lot of agencies do work with private contractors to do work. And the question is, well, are the records of private contractors subject to FOIA? The responses are, FOIA doesn't reach the records of private contractors. Yes, if the contractors are performing a government function. Or C, DC FOIA doesn't address the issue. So the question is, does DC FOIA reach the records of private contractors that are doing work with your particular agency? And here are the proposed responses. So pick your response. B is the correct response. A public body shall make available for inspection and copying any record produced or collected pursuant to a contract with a private contractor to perform a public function, and the public body with programmatic responsibility for the contractor shall be responsible for making such records available to the same extent as if the record were maintained by the public body. So in that instance, if it's your contractor, they're performing a public function, then you will be responsible for producing those records to the same extent as if those records were maintained by you. The Community Partnership for the Prevention of Homelessness is the type of contractor that DC Official Code Section 2-53283 is intended to cover. Should I process a FOIA request, or should I process as a FOIA request a request for copies of a public body's meeting minutes and charge FOIA fees? So if your agency has public bodies, one of the medical boards, or any other public body, and that public body under the Open Meetings Act has to keep meeting records, meeting minutes. Someone comes to you and requests copies of the meeting minutes of your public body. Should you process that as a FOIA request? Here are the responses or choices. Absolutely. They are public records, and FOIA and FOIA fees apply. No, because the meetings were open to the public and they had the right to attend under the Open Meetings Act. No, these are records deemed public information that must be publicly available without submission of a FOIA request. So your public body is required under the OMA to keep meeting minutes and meeting records. Someone comes to you and requests those meeting records. Should you process that as a FOIA request and charge the requester the applicable fees? C is the correct response. These are records deemed public information that must be publicly available without the submission of a FOIA request. Under DC Official Code Section 2-536, there's certain information deemed public information that has to be proactively disclosed without the need of a FOIA request, and they shouldn't be treated as a FOIA request. And here's a list of them. I'm not sure if the list is inclusive of all, but you can find the total list at DC Official Code 2-536. Employee salaries, titles, and employment dates, contracts, contract expenditures, budgets, manuals, policies, rules, opinions, final orders, and meeting minutes of open proceedings of public bodies. And again, closed provisions of closed minutes of the proceedings of public bodies are not subject to DC FOIA, but the open meeting minutes of public bodies are subject to FOIA. And since they have to be made publicly available, they should be made publicly available on the internet or on the public body's website. By law, they should not be subject to a FOIA request. Fees should not be charged for public records created on or after November 1, 2001. Each public body shall make the requesters those records just listed in 2-536 available on the internet, or if a website has not been established by the public body by other electronic means. So that information has to be already either on your website or available publicly by some forms of electronic means. And the legislative history of this provision makes clear that it's public information, and it must be made available without the submission of FOIA requests. Okay, you want to protect the requester's information and responsive records. You think the best way of doing that is in an encrypted email. And this encrypted email has a expiration date after which the information will no longer be accessible by the requester. It's sent to him or her by email with the responsive documents are sent in an encrypted email with which has an expiration date after which they will no longer be able to access information. May you do this under DC FOIA. And let's look at the choices. A, yes, that's a novel approach. Yes, it's the FOIA officer's choice. Don't do it, it violates FOIA. So A is, hey, that's a pretty novel approach. You're protecting the requester's identity, and you're making sure that no one but the requester can get access to that information. B, it's up to you. It's your choice. C, don't do it. It violates FOIA. So those are the responses. Take a few seconds and pick, make your choice. C is the correct response. Statute and courts hold it is a violation of FOIA. First, there is no statutory authority under District FOIA or the FOIA regulations for an agency to use an encrypted email to provide records to a requester. When this is done, the agency action is ultra vires. Secondly, since the record is no longer available to be assessed by the requester after a stated period, the agency is limiting the availability of the records to the public in violation of DC Official Code 2-534. If it's sent to the requester and it's going to expire in 3 days from the date the email was sent, and the requester doesn't open the email to day 5, then it's a problem. But you're also limiting the availability, limiting what the requester can possibly do with the record after he or she gets it, because once they get it, they are free to disseminate it further if they like. An agency does not comply with the FOIA when it produces records subject to restrictions on how those records may be used. Once records are released to the public in response to a FOIA request, the information belongs to citizens to do with as they choose. And they're the cases that so hold. Where the record expires or vanishes within a time frame, the resulting restriction prevents the requester from accessing or disseminating the record in the future. Your agency website reads, please use the FOIA portal for submitting all FOIA requests. It's the quickest method to get a response. And true, the FOIA portal may be the simplest and best means to submit and process a FOIA request, but may an agency require the public to submit through the portal? So can an agency mandate that all FOIA requests be submitted through the FOIA portal? Here are your choices. Yes, because FOIA's public policy is to minimize costs or the minimization of costs and time delays to persons requesting records or information. And that is a quote from DC Official Code 2-531. That's one of the public policies of FOIA, to minimize costs and time delays in processing requests. B, yes, because of the ease of use of the portal. C, no, an agency may not restrict the method a requester uses to submit a FOIA request to the FOIA portal. So those are your three choices. C is the correct response. Under 1 DCMR section 402.1, a request for a record of an agency may be made orally. That's one particular method. Under 1 DCMR section 402.3, requests may be mailed, faxed, or emailed. And while it's not in the regs, we know that requests also may be submitted through the portal, but an agency cannot restrict the method by which a requester may submit a FOIA request. Your agency has regulations that state certain requested information is exempt from disclosure. In reliance on this, an agency decides to withhold the information from disclosure. The question is, can an agency, in reliance on regulations that state that certain information is exempt from disclosure, withhold that information from disclosure? The choices are yes. Agency's position is sound since the regulation exempts the information from disclosure. The agency may rely on the regulation to withhold the record. Yes, but the agency must state the regulation in its response to the requester. No, this is not permissible under DC FOIA. So under DC FOIA, can a regulation exempting certain information from disclosure be the basis of withholding that information? And there are your three choices. And take a look at those and make your choice. And let's see what the correct response is. C is the correct answer. And we need to take a look at exemption 6, the other statute exemption under DC FOIA, which is found in DC Official Code section 2-5346. Exemption 6 specifically exempts information exempted from disclosure by another statute. And courts have held that statute should be is understood according to its plain meaning and does not include regulations or ordinance. So unless it is a statute, the exemption does not apply. And the same is under federal FOIA as well. So if there's a regulation that says it's exempt, that regulation is not sufficient under DC FOIA to withhold a document. It has to be a statute, and it can't be anything other than a statute in order to provide the basis of the exemption or the redaction to the document. If you want to read further up on it, the case is Newspapers Inc. versus MPD, and there is the citation for it. Requester says, I want the information in a spreadsheet. So you get a FOIA request, and the requester says, and when you get all the information, send it to me in spreadsheet form. Do you have to do that? Now, the agency does not keep the requested information in spreadsheet form. Here are your choices. FOIA officers should create a spreadsheet for the requester. I mean, that'll make it easy for the requester to disseminate the information and to read it and to look at it. Or the requester should supply the records in the form that the agency maintains. That makes it very easy and convenient for the FOIA officer. Or the FOIA officer can send the records to a third-party vendor that can timely create the spreadsheet. So those are your three choices. And let's look at the correct response. B is the correct response. FOIA does not require an agency to create documents or opinions in response to an individual's request for information or to obtain records from another agency or to answer questions that are posed as a FOIA request. So if you don't keep the records in spreadsheet form, if they're loose documents that are responsive to the FOIA request, send the documents as they are. You don't have to take the time to create a new document and put them in a spreadsheet because that's what the FOIA requester wants. Let's see some ID, please. Agency requires identification to process first-party FOIA requests. And we know that a first-party FOIA request is a request where a person is seeking information about themselves. For instance, I'm the requester and I'm trying to get some information that are in some government records about me. Is it okay to ask that individual for identification? Here are your choices. Yes, that is the only way to identify the requester as the person seeking records about themselves. No, you may not require the person to identify themselves to obtain records. Yes, that is the policy under DC FOIA. So the person comes in, you obviously don't know this person personally. They're submitting a FOIA request and they say to you, these are records about me. Can you ask them for identification? And here are your three choices. First party FOIA requests and requester identification. Absent statutory or regulatory authority, an agency who has a FOIA identity verification requirement, that requirement does not have the force of law. DC FOIA does not support a requirement that the requester present valid ID to submit, even if it's a first party FOIA request, and to obtain the record. Now, you can't ask the person for ID. I have not found any case law or incident if the person says, hi, my name is Johnnie Barton. I'm here to get some records about myself to prove that it's me. Here's my identification. And they voluntarily give it to you. So I haven't found anything on that, but that may be a different scenario altogether. And generally, the identity of a FOIA requester is irrelevant, and DC FOIA law does not require the requester to provide identification or to prove his or her identity. Except for cases in which the objection to disclosure is based on the claim of privilege and the person requesting disclosure is the party protected by privilege, the identity of the requesting party has no merits on has no bearing on the merits of his or her FOIA request. And, you know, pretty much the requester is probably wanting the specific information because it's germane to them and they want to use it in some fashion that identifies them in that particular document. So, you know, otherwise they would get the record unredacted with that PII redacted. But again, if they give you the ID voluntarily, that's a totally different scenario. You have not asked them for it. You have not violated any provision of FOIA because you haven't done anything. They presented it to you, and that's a different scenario. This is an interesting case. It deals with the personal privacy exemption as applied to a person who is deceased. And it's an interesting case to read if you have time to read it. If you ever come across an instance where the records are those of a deceased person. Under FOIA, the privacy interest in non-disclosure of identifying information may be diminished where the individual is deceased, but it does not appear. Instead, courts undertaking a balancing test must consider the effects of the death of the person in question, along with all other circumstances surrounding the disclosure request. In particular, individuals who are deceased, by definition, cannot suffer the personal injuries such as embarrassment that may come with disclosure, but certain reputational interests and family-related privacy expectations survive death. For example, an individual may be concerned about disclosure following death for reasons of reputation, civil liability, or possible harm to friends and family. That concludes the presentation. Here are our OOG contact information. Office is led by Director Nicole M. Allen, and there is her contact information. Below hers is mine. Cherie DeBurry is our attorney advisor. There's her information, and Cherie is our resident FOIA expert. Nicholas Well is our trial attorney. There's his information. Kayvon Bridges, who has been so helpful in helping to ensure that you all were able to see the presentation, is our IT specialist. That is his information. Kimberly Brown, our paralegal specialist, and that is her information. Again, I want to thank you for taking time out, and I want to see if I'm able now to look and see if there are any questions that need to be answered.
Hey, Johnny, this is Nicole. You have one from Brian Lambert from the Office of Planning. Can you see it, or do you want me to read it?
Okay, let me see if I can see it. Okay, I think I can see it.
Okay.
The privacy exemption exempts disclosure if disclosure is a clearly unwarranted invasion of personal privacy. If someone says they are seeking first-party information, but we think that the information is clearly unwarranted invasion of personal privacy, can we require them to show ID to overcome the exemption? Obviously, if it is in fact them, they can waive the exemption. You can't particularly ask them for it. You can explain to them that the record has to be given to them in the form that protects privacy, because you are unaware that they are the person. If they decide that they want to voluntarily prove that they are the person who it is, then obviously that's a different scenario, and it's something that probably won't cause any problem. Yeah, I'm still looking. Okay. I see. Can we cover ourselves by emailing or notifying the recipient that the record was in error and not for them? I would, but again, I would. Any action I take, I would take in consultation with the general counsel to let them know so they can immediately take whatever steps they think are necessary to show that they want the document removed from the public domain. Yes, you receive a copy of the presentation. Okay. Somebody said, no, I see two Johnnies. So there's only one Johnny now. Okay, let's see. Okay. I don't see any other questions that I haven't addressed. If there are, please let me know and we'll try to address it. And please feel free after the presentation to email myself or anybody on the legal team with any other questions you have or any other concerns or issues. We'll be happy to confer with you and consult with you. And I'd like to thank you all personally for being FOIA officers. We understand how taxing it is, how time consuming it is, and how it's a lot of work, and how sometimes you have to deal with difficulties. So on behalf of Director Allen and our office, thank you so much for doing the work that you do. And thank you again for attending this presentation. And if there are no other questions, I hope you all have a wonderful Friday and a wonderful weekend. And we hope to see you soon at our next training. Bye-bye.